Welcome back to Badge Breach, the show where we break down police encounters and sort out the who, the what, and the right and wrong of it all. Today's episode dives into speeding stops, officer discretion, and vehicle searches. This episode is brought to you by the Police Activities channel. Be sure to check the link in the description and show them some love. On April 7th, 2018, Officer Courtney Brown and Officer Christy Wilson of the Roswell Police Department pulled over Georgia resident Sarah Webb, allegedly for speeding, as she made her way to work in Duluth, Georgia. Once Ms. Webb came to a stop, Officer Brown approached the vehicle.
Stay in the car.
Sorry, my window doesn't hold.
Officer Brown, Roswell Police Department. You know how fast you were just going, ma'am?
I'm so sorry, I'm late for work.
So you could go over 80 miles per hour on 92? No, ma'am. You have your driver's license and your insurance card?
Yeah, my insurance.
Turn off the car and pass me the keys, please. The ground's wet. It's been raining. You're going over 80 miles an hour
so
on this type of a road. That's reckless driving, ma'am.
This is LexisNexis. I'm trying to look it up. I don't have it printed off.
Give me 1 second. I'll be right with you. Go for it. Hey. She was going like almost 90 down 92.
Oh, really?
She flew past me. I had to get up to 90 to catch her.
Wow.
My CAD's not working. Is yours? Did you?
I checked.
Can you see if can you check the tag too? I'm gonna have to restart this and see what the deal is.
Make me skid around.
I'm gonna take her probably for reckless.
Okay.
She flew past me going probably 80, 85 on 92 in the wet road. She said she's running late for work. I had to get up to 90 to catch her. What do you think? I mean, I don't have any speed detection, so at the same time, but...
Here's where things get interesting. Officer Brown admitted she had no speed detection device on her, no radar, no laser, nothing to give her an accurate reading of Sarah Webb's speed. So how does a case like this even hold up? The answer lies in Georgia law. While rules vary from state to state, Georgia allows a person to be convicted of speeding or even reckless driving based purely on an officer's visual estimate. No radar gun required. Georgia's speeding statutes are laid out in two sections of the state code. Section 40-6-180 requires drivers to travel at a speed that's reasonable and prudent for the conditions at hand. Section 40-6-181 sets firm numerical limits, the speeds you see posted on the signs. And Georgia courts have consistently backed up an officer's word alone. In the 1992 case Brown v. State, the Court of Appeals ruled that an officer's visual estimate of speed was legally enough to support a conviction, leaving it up to the jury to decide how credible that testimony really was. 10 years later, in Stone v. State, the court reaffirmed it. An officer's estimate on its own can support a speeding conviction. That same standard extends to reckless driving charges under Section 40-6-390, which applies when someone drives in reckless disregard for the safety of others. In the 2003 case, Fraser v. State, the court went a step further, ruling that speeding alone, even without any other violation, can support a reckless driving conviction if the state shows the driver was going at an excessive rate given the speed limit and the conditions at the time. So, putting it all together, under Georgia case law, a court would almost certainly find Officer Brown's visual estimate sufficient to support a conviction for speeding, and possibly even reckless driving. Now, a jury could still weigh her admission that she didn't know the exact speed against her credibility, but legally, her testimony alone would likely be enough. One important caveat, though. This is Georgia-specific. Several other states require actual radar or laser evidence and won't allow a conviction based on a visual guess alone of speed.
No, but you can use the fact that you were going whatever speed and she went past you.
Mm-hmm.
It's on camera, so you're going to have a back speed. You're going to have the fact that you went 90 to catch up to her. You're going to have too fast for conditions. And
Yeah, I mean, that's unacceptable. I told her, I said, you know the roads are wet, correct? You're running late for work and you're going above 80 to get to work. I said, call. So do not do that and put people's lives in jeopardy.
Yeah.
So, my CAD just froze on me, so I'm restarting it right now. What do you think? Or just tickets?
Atlanta answer or Roswell answer?
Hold on. Are you? Okay, hold on. Thank you.
Active, valid.
Yeah, sorry, she did it. Unavailable. My CAD's not working. Who's that?
A head, R tail.
Okay.
Now here's where this story takes a disturbing turn. Off camera, Officer Wilson pulls out her phone, opens a coin flip app, and says, "Heads or tails?" Heads, and Sarah Webb gets arrested. Tails. She walks free. Let's be clear about something first. Regardless of how that coin landed, Officer Brown likely had the legal authority to arrest Ms. Webb anyway, under both Georgia law and the U.S. Constitution. Here's why. Under Section 40-6-1 of the Georgia Code, most traffic offenses, including speeding and reckless driving, are classified as criminal misdemeanors. And Section 17-4-2 permits officers to make warrantless arrests for offenses committed in their presence. Even setting Georgia law aside, the U.S. Supreme Court has drawn a hard line here. In the 2001 case, Atwater versus City of Lago Vista, the court ruled that an officer with probable cause to believe someone committed even a minor crime in their presence may arrest that person without violating the Fourth Amendment. This despite the court itself acknowledging that the arrest at issue amounted to little more than needless humiliation inflicted through poor judgment. 7 years later, in Virginia versus Moore, the court doubled down, holding that warrantless arrests for offenses committed in an officer's presence are constitutionally reasonable. And that state law can't expand Fourth Amendment protections beyond what the Constitution itself provides. So legally speaking, a court would likely find this arrest constitutional, as long as probable cause existed. The coin flip doesn't change that. But constitutional doesn't mean acceptable. Departmental policy tells a very different story. The Georgia Department of Public Safety, for instance, restricts custodial traffic arrests to specific defined circumstances and prohibits them otherwise. The Roswell Police Department's own manual doesn't go quite that far, but it does instruct officers to favor citations over arrest whenever appropriate. More damning, though, is what deciding an arrest by coin flip says about the officer's conduct. Roswell's policy manual calls on officers to carry themselves in a way that earns public trust and respect, and to serve the community with kindness, consideration, and patience. A coin toss deciding someone's freedom, that's hard to reconcile with either standard.
Totally.
23.
Michael Jordan? Hi. So I got too fast for, let me write this down.
Too fast for conditions.
Is it reckless?
Yeah, you can do reckless, and then speeding. And you're just gonna have to mark the pace one instead of the...
I mean, either way, the speed limit here is what, 45?
Yeah.
45.
She was going way.
Yeah.
I mean, because I haven't done one like speeding like that, so that's why I'm a little bit unsure.
You're gonna do the patrol vehicle spot, and then it's gonna ask you for moving or not moving, and you're gonna do moving.
Can you help me do these dang tickets? My CAD won't even log me in. Sorry. Alright, I'm gonna go. Yeah, that's not okay. Yeah. Alright, ma'am. Do me a favor and step out of the vehicle for me. Put the phone down.
Why am I
Put your
doing
phone down. Step out of the vehicle. Turn around, put your hands behind your back. Because, ma'am, you're driving entirely too fast for conditions. You put a lot of people's lives in jeopardy, okay? Double locking these so that they don't tighten on you. Do me a favor and step in front of my vehicle, ma'am. Step in front of my patrol vehicle. Do you have anything? Do you have anything? Do you have anything in your pockets? Do you have anything on you that poke, stick, or stab me? Any drugs, paraphernalia, anything like that? Okay. You have a bond. Turn to the side for me. Here, move on, Burkett. I'm just gonna shake this out, okay? Alright. Do me a favor, step over here. It's my patrol vehicle. Have a seat for me. We're gonna buckle you in, okay? Alright. RDR 390R. Alpha 1 in custody.
919.
Alpha 1, can you please send me 85?
Here. With Ms. Webb detained, Officer Brown moves to the vehicle and begins a search. So let's break down the rules here, because vehicle searches are one of the most misunderstood areas of Fourth Amendment law. First, the basics. A traffic violation alone isn't enough to justify searching someone's car, but there are several well-established exceptions that give officers that authority. The simplest one, consent. If a driver agrees to let an officer search the vehicle, no probable cause is needed at all. An officer can ask, and if the answer is yes, that's the end of the analysis. Then there's the automobile exception, first established by the Supreme Court back in 1925 in Carroll versus United States. Under this rule, officers can search a vehicle without a warrant if they have probable cause to believe it contains evidence of a crime. The court expanded on this in 1991 with California versus Acevedo, ruling that this same probable cause standard extends to closed containers found inside the vehicle. But here's the twist. This wasn't a probable cause search at all. What Officer Brown appears to be doing is an inventory search, standard procedure before a vehicle gets towed. The Supreme Court addressed exactly this scenario in the 1976 case South Dakota versus Opperman. The court explained that when police impound a vehicle, they routinely inventory its contents, and for good reason, to protect the owner's property, to shield police from false claims of theft or damage, and to guard against potential danger. The court ultimately found that this kind of routine inventory following standard procedure doesn't violate the Fourth Amendment, and Roswell PD's own policy manual backs this up directly. It requires officers to inventory and document the contents of every vehicle taken into impound. So because Officer Brown appears to be following that exact protocol, a court would most likely find this search constitutional, not because of probable cause, but simply
Take
because
your phone
it's
with you.
standard
Now your makeup
routine
bags and all that.
procedure.
Is it okay to leave those in the car? Cause
Have
to be at work. Is there any way I can just
You
get a
can-
ticket or something?
you can make a phone call, but that's all you can do. If you want to call them, you're allowed to call them, but
Okay.
okay. Give me 1 second, I'll let you call them, okay?
Hey, I'm going to jail.
Where does he live?
Go to jail for reckless driving or speeding. He had to be doubling his
Wow,
speed.
this is in a bad mood.
Okay, have a good day, sir.
There's no reason that I should be.
In the end, Sarah Webb was arrested and charged with driving too fast for conditions and reckless driving, but those charges wouldn't stick. On July 18, 2018, they were formally dropped. That same period, Roswell Police Chief Rusty Grant addressed the incident head-on in a video statement posted to Facebook, condemning the officer's conduct and announcing a top-down assessment of the department, including an outside consultant brought in to conduct a full audit. 8 days later, on July 26, 2018, both Officer Brown and Officer Wilson were terminated following the internal investigation. So let's hand out our final grades. Officer Brown and Officer Wilson. That's an F. Not because everything they did was illegal, much of it technically wasn't, but choosing to arrest someone by coin flip instead of simply issuing a citation reflects a serious lapse in judgment, a violation of departmental policy, and frankly, a failure of character. Here's the thing about policing. It's not just about staying within the bounds of the law. It's about making the most reasonable, most ethical decision available within that authority. Most officers take a law enforcement oath of honor alongside their oath to the Constitution, an oath built on accountability and high ethical standards. When an officer reduces a person's freedom to a coin flip, they're not just bending policy, they're breaking that oath. And they're reminding their community exactly why trust in law enforcement has to be earned, not assumed. To Roswell PD's credit, they didn't look away from this. They took decisive action, and that matters. As for Sarah Webb, there's really no grade to give her because she never had control over how this played out. When Officer Brown first told her she'd clocked her going over 80 miles an hour, her reaction on camera was one of genuine shock. And later, Officer Brown herself admitted she didn't actually know Ms. Webb's real speed. That admission alone raises a serious question. Was this stop ever built on a lawful foundation to begin with? What we do know is this: despite everything, Ms. Webb remained composed and cooperative throughout the encounter, even while visibly upset. That composure likely played a real role in getting the charges dismissed. And beyond that, she did exactly what she should have. She followed up through the proper channels and filed a complaint. So, to Ms. Webb, well done for handling an incredibly difficult situation with grace. That's it for this episode of Badge Breach. Got an interaction or legal topic you want us to break down next? Drop it in the comments below. Thanks for watching. We'll see you next time.